we can get started. Hello, everyone, and welcome to this masterclass on intellectual property. This is another masterclass from the autumn season. We've got a great panel today and a lot to get through. So we hope you enjoy this masterclass and get involved with the conversation. So we always start our masterclasses with our learning outcomes. So by the end of this masterclass, you should know how to break into the practice area, know what the work of an intellectual property solicitor involves, and know the key issues facing this practice area right now. Before we get going, I'm just going to quickly run through some house rules. First and foremost, please use the online question tool to post any questions that you have, and my colleague Liv will be posing them to our speakers at the end. Liv will also try to keep an eye out on if any relevant ones come up during the conversation too. Please also use this tool to let us know if you have any audio or visual problems during the masterclass, and we'll do our best to help you. Please note that this masterclass will be recorded. The recording of this session will be sent out to all registered after the session in the follow-up email, and will also be available on our YouTube channel very shortly as well. Please feel free to also post about the masterclass on social media using LCN Masterclass and tag us as well. And finally, we have some fantastic masterclasses coming up over the autumn term. So please check out the lawcareers.net events page for all masterclasses we're running this term. Next one is next Tuesday, and that's called Researching Law Firms, Identifying the Firm for You, which will cover places you can get crucial information, the differences between types of law firms, the importance of networking, and more. And our next practice area masterclass is on the 8th of October, and that's all about private equity and investment funds. We'd love to see you at any and all of our events this term. Okay, so I'm just going to start off by asking all attendees to answer the question on this screen so our panelists get an idea of everyone's stage. Thank you for that. So I'm just going to share the results. So it seems we have a few first-year law students. Mostly we have second or third-year law students and postgraduate students, as well as some non-law students and people in work. Great. This will help our panelists today understand what stage everyone is at. And I would quickly like to find out how much you already might know about this area. So I'm going to pop in another poll for you to answer for me, please. I see majority of you are saying that you know a little about about intellectual property in the practice area, and some of you know absolutely nothing, which is totally fine because again, this is what the session is about. So great. I think we're about ready to get the conversation started with our panelists. So I'm going to hand over to my colleague Liv. Thank you.
Thanks, Dimitar. Hi, everybody, and yeah, thank you all for being here today. We've got a lot to get through, so I'm just going to kind of get stuck in straight away. So first up, if I could just get our panelists to introduce themselves, that would be brilliant. So I'm going to go with the order on my screen. So if Luke, you could start that off for us.
Sure. So I'm Luke Maunder. I'm an associate director at a law firm in London called Osborne Clarke, albeit it's got offices all over Europe. And I specialise in intellectual property, as you would expect.
Well, thank you. And Adrian?
Hello, my name is Adrian Chew. I'm of counsel at Bristows, which is another law firm in London, and I particularly specialise in patent law, which is a type of intellectual property law.
Perfect. Thank you both so much. So to kick us off, I thought it would be quite useful just to go through the different types of IP lawyers and the different parts of the practice area. So Adrian, if we could come to you for that, please.
Sure. So Bristows is a specialist IP firm, so we might be slightly different to some of the other firms and how we're set up. But here we generally split ourselves between patent litigators, and patents are a form of intellectual property, trademark, copyright, and design right litigators, so people having disputes over those. Then we have transactional teams who deal with all IP rights, but on a kind of contractual basis. That is broadly how Bristows does it. In other firms, you might be part of an IP department where you practice all different types of IP, and you might be attached to a transactional side, or you might be attached to a litigation team.
Great, thank you. I think also worth thinking about how IP itself kind of fits into the everyday, just for our audience to kind of get an idea of like how it works in the day-to-day world. So Luke, come to you for that one, please.
Sure. So, I mean, when I say this to my kids, they roll their eyes at me, but IP really is all around you in the day-to-day world, and you interact with it quite a lot without knowing about it. Adrian's covered some of the topics or the key IP rights. Patents, for example, are very important when it comes to medicines and the discovery of new medication and that sort of thing. So there you will interact with it. Trademarks, you will all know and love, things like Coca-Cola or taglines from car adverts, etc. These are trademarked, and those rights are very valuable. Stop other people using the same name for products, etc. Copyright, everyone's probably an infringer on the call, but for the fact that you have sort of reasonable use defenses and things like that. So everything that you do sort of day to day, chances are there is an IP right involved somewhere, from the smallest thing of my 9-year-old drawing his own intellectual creation in terms of the Ichabod drawing I've got on my desk, all the way up to a large multinational using IP rights as a means of shifting profit margins around a sort of global network of companies.
That's great. Such a lovely way to put it as well. Perfect. Next up, we've got the sorts of clients that both of you work for. So Adrian, if you could chat a little bit about the clients that you work with.
Sure. So, Liv, as I said, I specialize in patents, and I particularly specialize in pharmaceutical biotech field. So my clients are pretty much invariably large and small pharmaceutical and biotechnology clients. The firm more broadly acts for different people in the kind of patent field. So we often work for people who in the mobile phone industry and are involved in standard essential patents. And I won't go into more to them because Luke is by far the expert compared to me in those. But other clients the firm works for more broadly. So in trademarks, a big client is Diageo, and obviously they've got a big portfolio of work. And McDonald's is one as well. So, you know, anyone who relies on their intellectual property as an important part of their business, so people selling things for trademarks or people designing or creating things or inventing things, are usually clients of firms like us and our firm.
Great. And Luke, is your client base a bit more broad than that?
It is, yeah, it is a little bit more broad. Full disclosure to everyone, Adrian and I worked together for a decade before we moved to different firms. So I did used to work with him. But so Osborne Clarke, we have a sort of wider client base by virtue of the fact that I tend to do stuff outside of patents as well as patent law. I'm very much on the technology side of things, so I don't tend to dabble in drug cases and life sciences companies. So a lot of my clients are all the household name tech companies that you will have all heard of, and social media platforms, that sort of thing. But really they span all aspects. So we do a lot of work with retailers. We have a number of fashion houses as clients. And even people who make just little engineering widgets who rely on their IP to make toys for kids. We have some of those as clients. So it really is a broad client base, I would say.
And you've mentioned briefly kind of the sort of types of issues, but I wondered if you could go into a little bit more detail about the problems, issues that you might find yourself dealing with.
Yes. So I mean, Adrian mentioned that one of my specialties is standard essential patents. I have no wish to sort of delve into that sort of topic in a lot of detail, but as he mentioned, there are lots of issues around IP rights, which are, generally speaking, they're monopoly rights or exclusionary rights. So they're right to do something and to stop other people doing it too. And there's a tension between that and interoperability, so the need for my iPhone to be able to talk to your Android phone, to be able to talk to the mask that is made by whomever it is made by. So I get involved quite a lot in that sort of nitty-gritty, very obvious dispute. But more broadly, IP rights, you tend to have two very high-level issues. Are they valid? So were they validly granted? Was the patent new and inventive when it was obtained? Or are they infringed? So does my patent cover the particular activity, and that's give me the right to exclude someone else? So issues at a very high level tend to fall into those two streams.
That's great, thank you. I'm just looking at the audience questions as they're coming in, and there's one here that I think might fit quite nicely on this topic, and open to either of you. What are the strangest, or what is the strangest case that you've worked on? If you're able, obviously no names, I assume, but
what is the strangest case that I have worked on? I mean, I have done one case that's what's the phrase? Not safe for work, even though it was work. So that's probably the strangest one I've ever worked on. Adrian, how about you?
Yeah, it's surprising what you see disputes on. I think we once were involved in a dispute around contraceptives, for instance, and patents. So I mean, it's surprising what you would think that patents protect. Yeah.
perfect, thank you. And Adrian, just sticking with you, what would you say the pace of work is like for lawyers in this area? Do you find that yourself kind of having really busy periods and then fairly quiet periods, or does it tend to be pretty steady?
So it really depends on, I've worked at other firms as well and from other colleagues. It depends at the firm you are at to a large extent, but it also depends on the kind of law you do. So as I'm a litigator, there are, by necessity, there's peaks and troughs because there are certain court deadlines you need to meet, and then that will accelerate the amount of work you need to do, and then unexpected things happen. But at the same time, you can expect a reasonable level of busyness. It's not as bad as it can be in other fields where, you've gone from doing nothing to doing, working all night. It's predictable to a large extent. So I would say it's fairly even overall.
Great, thank you. And then Luke, what would you say a typical day in the life is like? I imagine there isn't really a typical day, but just a general day in the life.
Glad we acknowledged the elephant in the room with that question. Yes, there is never a typical day. So on a typical day, I probably drop off my kids, get on the train up to London. I work in London 2 or 3 days a week, work from home the rest of the time. Check my emails on the train, sort of try and prioritize my day. And then during the day, I will probably spend a small amount of time drafting something, skeleton argument, witness statement, advice note. I'll spend a number of hours probably on calls with clients or in meetings with colleagues about what the advice is going to be, talking through the issues, trying to sort of get to the commercial nub of things, because we find it's always easiest to talk things through. So we do like to talk about what's going on. And then probably a little bit of time I devote to not working on the law, because things like client relationship development, business development, DEI initiatives are all very important here at Osborne Clarke. So we get sort of dedicated time that we're expected and want to work on those things as well. So I'd say it's pretty varied, but probably roughly what you would expect. I do not sit and work on a contract all day, and indeed that's why I'm not a contract lawyer.
Great, thank you. And just sticking with you, I guess one of the important things for those kind of thinking about a career in law or in IP more specifically is whether the area is international in terms of the work. So how international would you say your work is particularly?
So I would say it's pretty international. There are a number of IP rights, and patents are a good example where international bodies grant them. So the European Patent Office, for example, grants EPs, European patents, that then come as a sort of bundle of European rights. So quite often I'm liaising with foreign counsel to talk through issues to make sure we're aligned across multiple jurisdictions. And often cases tend to be in multiple jurisdictions. We'll have sort of parallel actions. That's very, very common. I'm sure Adrian would agree. So I would say pretty international.
Brilliant, thank you. And now I think for the benefit of the audience, it'd be interesting to hear about both your journeys into this area, how you kind of came to be practicing this area of law, and what it was that drew you to this particular area as well. So Adrian, if we start with you on this one.
Sure. So my undergraduate degree was in biology, and I really enjoyed science, but I just wasn't a very good scientist. And so I quickly realized during my third year that there wasn't going to be a career for me. And I took some time out, worked, and what I did, I thought I'll do the conversion. So I did the GDL as it was then. I'm not sure it's that anymore. And while I was doing my LPC afterwards, I got a training contract at Pinson Masons. But when I got my training contract, which is rather late and the kind of traditional route, it was the height of the financial crisis. So there was no chance of me going there straight away. And I was looking for jobs. I did a little bit of immigration law. And then I got a job as a paralegal at Bristows. And I spent 2.5 years here working on cases for our pharmaceutical clients and very much enjoyed it. But then I went off to do my training contract at Pinson Masons. I stayed there for 3 years before coming back here as a qualified associate. And all I can say is that having been a paralegal for 2.5 years and then gone on to do my training contract, it was a big help because you're just really familiar with the administration side of what a being solicitor is.
Great, yeah, I can imagine that experience was kind of invaluable as well. Luke, was yours very similar to that or slightly different?
Similar in some ways, different in others. So I've got a computer science degree, but I can't program for toffee. So that very quickly seemed to be a bad plan to make a career out of. So similar to Adrian. But I then thought, I know, why don't I go and become a banker? So I worked for Lloyd's TSB for a year. Then immediately went and studied law to do my GDL. So you can work out what I thought of banking. But didn't get a training contract actually until after the LPC. So I sort of left law school without a training contract, worked as an advocate in the county courts for a number of banks, amusingly, for a couple of years and I think I did about 1,000 court hearings over 2 years. And during the course of doing that kind of gave me the experience that Adrian's just talked about to kind of get a training contract. Got one at a small high street firm where I ended up doing a lot of country sports law, which Adrian always finds amusing, for a while. And then as soon as humanly possible after qualification, which is I think 6 weeks, I managed to get a job at a commercial firm on the basis of wanting to do IP, and then kind of moved up to where I am from there.
Great, thank you so much. And Adrian, just coming back to you, did you sit in an IP team when you did your training contract? Is it an area that you think people need to kind of do during their TC, or are there other ways to get into IP?
So I did, and at Bristows you invariably do a seat which involves IP. As you think you're guaranteed a patent litigation seat because that is what we are renowned for. But there are other ways of doing it. So I mean, you could be a paralegal, do your training contract, and come back and qualify as an NQ in that area. You could be, a commercial litigator and suddenly spend a lot of time doing intellectual property related work and move into that. There's definitely some very successful partners at other firms who have done that. You can always make a change. There are ways for it. So, I mean, patents are a bit trickier because they're quite specific, but definitely for soft IP or moving towards more IP related contracts is it would be not unusual to start somewhere else and end up there.
Great, and just sticking with you, do you think it's important to have, we've got it's one of the questions on my list, and we've got a few that have come in around the same thing, but do you think it's important to have kind of a STEM or a technical background to give yourself a bit of a boost, I guess, to get into the area, or do you not think that's necessary?
So for copyright design and trademarks, then absolutely not. You don't need, there's no advantage of having a technical background there at all. And even for patents, while some firms can be a bit sniffy about it, Bristows is not one of them. I don't believe Osborne Clarke is either. Because in reality, by the time you're practicing that area, you're so your undergraduate was so long ago that what you learned there is no longer relevant. And really, what you learn as an undergraduate is not the kind of cutting edge technology you deal with as in a patent dispute or in patent law. So it definitely can help. It is an advantage. But if you were interested in patents or interested in IP and you don't have that background, by no means will it stop you. As long as you're willing to learn about it, because the technical background is a very important part of patent law. You can't do, you have to try and understand it and speak to experts, then you're absolutely fine. So I think no matter your background, feel free to pursue a career there. If you've got a technical background, it can be a plus.
That's great, thank you. And Luke, just to pose that one to you as well, would you agree? And also, just to jump on one of the questions from one of our panelists, one of our panelists, you're the panelist, one of our attendees, Sven's asked whether it's harder to get into IP if not from kind of a sciencey background. If so, is there anything you would advise them doing to flesh out their CV if they're not from a STEM background?
Mm-hmm. I would agree and echo exactly what Adrian has just said. I think it is certainly not necessary. Osborne Clarke is certainly not, how did you put it, Adrian? Sniffy about it. In terms of, we don't require people to have a STEM background or anything like that. Also, it's only truly relevant to patent law if we're being sort of, narrow about it, because you can practice trademarks or copyright without needing any kind of technical background at all. But the most important thing is to be inquisitive. So when we say it's be great if you had a STEM background about something, what we mean is you can read a patent about some complex issue. In my case, it would be a telecoms patent or something like that. In Adrian's case, it would be a drug patent, and understand it, or seek to, or be willing to seek to understand it, to be interested in it. It's kind of a shorthand for that. If you have that interest, absolutely no problem at all. It's the same skills in any area of law, an analytical mind, etc. So please don't think IP is closed off if you don't have a STEM background. That's absolutely not the case.
And you mentioned that the skills required are very similar to other areas of law, but are there any kind of key skills that you say have really benefited you, perhaps earlier on in your career, that you felt were really beneficial?
So it's interesting. I mentioned, the usual skills of being a lawyer. You need to be organized. You need to be able to prioritize things under pressure, because, we are frequently under pressure and we frequently have competing priorities. And you just need to be able to keep the plate spinning. But the thing I would say that really benefited me early in my career is absolutely probably not something I'd call a skill. It's just being really inquisitive and loving tech. In my particular case, I love tech. I play with tech all the time. I've got, I'm the random person who's got those actual light bulbs I can turn on and off with Alexa. So when I read patents, I genuinely like finding out about what they're about. When I go to talk to someone about copyright infringement and when there's an AI issue, I just find AI fascinating. And if you're like that, that will come across. So I would say, be passionate and interested in the subject matter. It's not a skill, but I would say it's quite a useful trait.
Definitely, I think that's the case for a lot of things as well, just having that drive and interest, isn't it? Perfect. Adrian, coming to you next. We've touched a little bit on the experience that you had before your training contract to the paralegaling. Is there any experience that you'd recommend aspiring lawyers get to kind of give themselves a boost, as I mentioned earlier, to get themselves into a career in law, if it is something, a career in IP law rather, if it's something they're interested in? Is there any kind of specific experience you think would be beneficial?
So any experience in a commercial situation where you're dealing with IP law is really beneficial, because when you get to the training contract question about why us or what you're interested in, it gives you, you actually have experience to speak for, because otherwise I think it's quite difficult. So I often interview prospective trainees, and if I said, oh, why Bristows? And they said, oh, I really like IP. And I say, well, how do you know you like IP? And they say, well, I watched this webinar. I'd say, well, that's a start. But really, what do you like about it? How do you enjoy it? It's not the same as like, I like listening to music. Great. That's great. But why do you want to practice the rights underlying that music and potentially, represent Ed Sheeran in a kind of copyright case? Why do you want to do those things? And so I think it's going off, and any kind of work experience anywhere can be really useful. So, working with your friend who has a studio, and, you recorded something and you learnt about the rights behind that recording, really useful. That shows you're actually interested and it's relevant experience. Obviously, then there's paralegaling and vacation schemes if you get a IP specific law seat, but they're harder to get. So really just be creative.
Great, thank you. And I believe, and correct me if I'm wrong, Adrian, that IP just hosts some, Bristows just hosts some IP workshops as well throughout the year.
We host IP workshops and summer schemes, which are perfect ways of getting to know the area a bit more and seeing if you're interested. But I think you still need to say why you're interested. That's the important thing.
Perfect. We're going to move on to some kind of looking at how you guys get the work in. So Luke, just coming to you first. What's your role in getting business development for the firm, or whose role rather is it?
So that's a really interesting question. I think there's a bit of a misnomer that partners go out and get them work and everyone else just does it. I would say that's not true in today's day and age at all. So for example, I'm an AD, which is sort of similar to Adrian, and I am certainly, actively encouraged to engage in business development, to have ideas, to put together presentations, to go out and give those presentations to clients, to go to conferences, all this sort of thing. And I think partly that's because the old model of the partners got the work and everyone else just did it was a bit silly, because it meant when you were suddenly a partner, you had no clue how to go about business development at all, having not done it before. So I'm encouraged to be involved. Obviously, if I bring something in, that's great. If I don't bring anything in, that's also fine too, right? Because it's a learning process and a development process. But Osborne Clarke encourages everybody, all the way, from partner, all the way, obviously, but all the way down to trainees. We all have a personal budget that is for business development. We are all encouraged to use it. We are all encouraged to go out and start making connections, get to know people at the sort of place that would refer us work. And to just engage in that side of things.
Great, thank you. And Adrian, how does your practice at Bristows kind of engage with the rest of the firm? Do you find that you're kind of work independently, or are you interacting with other departments quite regularly?
Yeah, so as a firm, Bristows is obviously a very IP heavy firm, where that's where our main bank of our expertise. So anywhere in the department that we interact in various different ways. Me personally, for instance, I always do pharmaceutical patent disputes or biotech patent disputes, and that means I always deal with our regulatory team, and regulatory here is about the process of the approval of medicines, that saying that they're safe and effective. I deal with our competition team because there are often competition law issues around patents, because as Luke says, they're the only kind of monopoly you're allowed, and competitive behavior as a whole. I deal with our commercial team because I often have to have issues around licenses or settlement agreements. They're the main departments I work with. Sometimes I work with the contract dispute department because they deal with IP heavy contracts, and I often help with them, but not the contract side, more the patent side. But there are other departments which I don't work with really. So I don't really work with the corporate team here who do quite big, large scale IP heavy M&A. But they in turn work with the commercial team. So in a way, we're all interconnected, but those are the people that I deal with directly day to day.
Brilliant, thank you. And we spoke briefly at the start about kind of the pace of the work. I was just wondering whether both of you wanted to kind of chat a little bit about managing work-life balance in the world of IP patent law. So Luke, perhaps starting with you.
Yeah, so I think Adrian and I are quite lucky because we work for two of the firms who are kind of probably best known for culture and work-life balance in the city. Obviously, you can get very different work-life balance out of the city in the regions, but we're both quite lucky in that we're both somewhere where we can manage our work life quite easily, and we get to. I mentioned picking up my or dropping my kids off earlier. You know, I do that several times a week, which is quite rare for city lawyer to do. I know Adrian does the same. So we can manage our own time to a significant extent, and there's quite a lot of, in the IP world, there's quite a lot of respect for that, I think. So but really, the most important thing about that is just being transparent. But so this is when you're available, this is when you're not. Is that okay, sort of thing? And then being flexible. So, you know, sometimes I can't do something because something has come up, but that's just the sort of life of a professional. And fortunately, it doesn't happen that often, right? Things can usually be structured around days. So no real tips apart from being upfront, etc. But yeah,
That's brilliant. No, thank you very much, Adrian. Coming to you next.
So yeah, I'm just echoing what Luke says. Like law firms in general have appreciated that work-life balance is really important to people, especially now. Not everyone wants to become a partner, so you know you're not going to have the freedom that partners get sometimes. But what different firms mean by work-life balance can be different things, and what you should look for when you're looking for a firm is somewhere where you can work what you want to work, but get paid what you want to pay, because that's the offset in the city. So if you want to work very hard, you can do, and you could get paid more money. I mean, that's just how businesses work. And if you want to work less hours, then you look for firms which accept less hours, but you might not get paid as much. I mean, that's just frankly how it works, because as lawyers, you bill for your time. And so the more time you bill, the more they can afford to pay you. But at Bristows, we don't have billable targets, but instead we try and work, quite hard during the core hours of the day and then leave it and start again the next day. And that's what most people do. I personally stop at 5 o'clock, which is a bit earlier than everyone else, who usually work until about 6 or 6:30. And then I go home because I live outside of London, and I see my kids, and I try and get them to do their homework while they ignore me, and maybe cook dinner or something. And then when they're in bed, I work again. So I do that 5 days a week. And so I'm not really working any longer than anyone else in the office, but I'm splitting up my time, which makes it possible to see my family more. And so I appreciate that, and I'm very happy with that. But if you don't want to do it that way, you don't have to. And so looking for a firm which offers you that flexibility, I think, is really important if you want to seek your work-life balance.
Brilliant. Thank you both for being so honest with that. That was really helpful. I'm just going to move on to hot topics and future trends. We've got a lot of questions coming in, as you can imagine, about AI. So I'll go through the questions that we've got, and then we can see whether there's any extras that we in the Q&A that we've missed. So Luke, what are people in your practice area talking about this year? Have there been any significant changes or developments recently, or that are maybe on the horizon?
So there's always some case that's important that everyone's suddenly talking about, but I mean, in my side of things, so on the technology side of things and IP rights, inevitably it is artificial intelligence. I've now actually finally given in and started calling it that instead of machine learning, which is what it is. But yeah, AI is a massive topic for us. It affects all our clients. There are a number of unique issues in IP. The obvious one being training data and the use of the sort of internet to train these GPTs, these fast AI models. So that's quite a big issue, how that interacts with copyright law. Big issue at the moment. There's a big case going on called Stability AI against Getty Images, who you may or may not have heard of. That's big in patents as well. You know, to what extent can you patent these things? There's all these digital regulatory issues which are kind of IP adjacent around being able to predict what the AI does. AI is now being regulated by Europe. There's an AI Act coming in, so it has a significant effect on my work and the world of IP rights. And then if you add to that, just completely park all of that, which is already a big topic, you know, how I use IP at work is important. So I have something called OCGPT, no prizes for guessing what that is, so I can use, you know, I have an AI tool that's like a walled garden in the firm that I can use to help me in my day-to-day job. And it's very good at certain tasks and not very good at other tasks, as you'd expect, like any AI model. So, and it's working out how to use that to best service our clients. So not only is it affecting my work, but also like it's a tool I have at my fingertips that I can use as well. So both sides of it.
Brilliant, thank you. And Adrian, obviously it's all very fast moving, lots happening. How do you stay up to date with the latest developments, and what kind of strategies would you recommend to those coming into the profession to help them with their applications and things like that?
Sure. So I personally have been working in the area for quite a while. So to keep up to date, I receive a couple of bulletins which are pharmaceutical specific, so about different trends in pharmaceutical companies or new clinical trial results, which I don't think you necessarily have to read, but that's what I do. And then I try and follow every single patent decision as it's released. So I generally, there's not that many of them. There's maybe like one or two a week. So it's not an insurmountable hurdle. So once you do that and you keep following all the judgments, that's how you kind of keep abreast of the law. We also have know-how sessions, most firms do. So every month, every 2 weeks, there'll be presentations on various topics. And sometimes I go to conferences and evening seminars. But that's all necessary for me to become, you know, to be an expert in my area. For people interested in law, in IP law, then broader commercial awareness is really important, because in the end, law firms are businesses, and businesses make money by providing services to clients. So knowing how things interact commercially is really important. So reading a good business press, City AM is absolutely fine. You know, just keeping on top of what's happening and why IP might be important for those in the industry is useful. So what did I see today? Nintendo suing Power World for patents over, which says it covers, you know, the kind of Pokemon. It might be really interesting to you if you're really into gaming, and is completely IP relevant, and you could read about around that, and, you know, works every way round. So and then more broadly, it helps you with your commercial awareness, because just learning these kind of business terms and how businesses work, that's what law firms are looking for. So I would say that's the best way, easy way of doing it. If you wanted something IP specific, then a very common blog which covers a broad range of IP issues is IPCat, and you can subscribe to that and look at posts of that. But that can get, it's a bit weird sometimes and can be quite technical, but that is very IP specific.
Thank you. And how do you see, Adrian, the world of patents evolving over the next few years?
So the big new development in patent law was the new UPC, which is a European-wide patent court, and the potential for unitary patents, which are patents which cover multiple jurisdictions. Now, normally things are very territorial, so each patent only covers the country it's granted in. So people are very interested in there being a new specialized patent court which deals with what we call the European Patent Convention, which we're a signatory to. Following Brexit, the UK couldn't be part of the UPC. And originally we were going to host one of its main divisions, but Brexit has put a stop to that. And so it will be interesting over the next 3 to 4 years, I think, to see is how the UPC, how prominent part it plays in patent enforcement across Europe, and what that means for the UK market, and how UK solicitors and barristers and patent attorneys work in the UPC, and how their strategies work together. So I think that's definitely one to watch. But I would say that if you're going to put a training contract application in and mention the UPC, be prepared to talk about it, because it's one of those things that always piques interest and you might get lots of weird questions. So just make sure you research the topic properly.
Brilliant. Thank you very much. And just before we go on to the some more of the attendee questions, Adrian, I wondered if you wanted to share the case study that you prepared for us today.
Sure. So I thought would be interesting to get a flavour of what I do is talk about a case I was involved in, which was about a drug called apixaban. Now, apixaban is a blockbuster drug, and it's sold by BMS and Pfizer, and it had, it's a very valuable drug. And for something to be a blockbuster, it means that its worldwide sales are over $1 billion. And this was this drug sold for multi-billions of dollars. Bristows were acting for Sandoz in that case, who are a generic company. Now, generic companies make copies of originator drugs. So once the patents expire or invalid, they make drugs which compete on the market. So give an example is everyone's heard of Nurofen, right? So Nurofen is the painkiller, and that's a branded generic. Originally there would probably be patents protecting it, and there might be patents protecting certain formulations. And Nurofen maybe sells for £3 a pack, say. Generic ibuprofen, so if you walk into Superdrug or Boots, you can buy that off the shelf for 20p. And that is a generic version of Nurofen. So it contains the same active substance. It might be a different formulation. But that's the kind of industry that I work in. And we were successful in the Patents Court and in the Court of Appeal in revoking that patent. So we said that the patent protecting apixaban was invalid, and the court agreed. And because of that, Sandoz and other generic companies could launch their generic product onto the market much earlier than they would have been able to otherwise. And as a result of that, the NHS can suddenly save quite a lot of money because they are selling the generic drug cheaper, and other companies face different competition in the market. So it was really quite an interesting case because it had such a broad applicability across the UK. It wasn't like a small product in a small market. And it affected the way people prescribe drugs. So I remember interviewing a pharmacist for a training contract, and he said, "Oh, great, I remember that happening because suddenly we started doing all these generic prescriptions instead, and we moved people from different drugs." So it was really interesting and really exciting.
That does sound fascinating and such a good insight into the world of your work. So thank you very, very much for sharing that with us. I'm going to move on to some of the audience questions now. We've gone through a few of them as we've gone. I've popped in a few, and I think a few of our questions that we'd already prepared had answered them. Luke, someone has asked whether there are many opportunities for secondment in IP law. I wondered if you knew anything about that.
Yes, absolutely. Lots of opportunities. And I can say that not just about Osborne Clarke, where secondments are quite common, but also about previous law firms, including Adrian's. They're very common. They're usually to pharmaceutical companies or technology companies. But these companies have huge IP demands, and often a secondee from the IP team is important. So absolutely yes is the answer.
Fab, thank you. And obviously we spoke quite a bit earlier about STEM backgrounds and that sort of technical backgrounds, that sort of thing. Adrian, you did a science-based degree. Did you find that, or have you found that most IP lawyers or patent lawyers did non-law degrees? What sort of degrees were people doing?
So it is a real broad mix. One of the best patent lawyers in the department I know did her degree was in classics. And she was one of the few solicitors patent specialists who works equally comfortably across life sciences and tech matters. I mean, she's very clever, don't get me wrong, but you know, the background doesn't make a difference in a sense of she's willing to learn the background, and she's clever and she grasps it and she speaks to experts. So I would say in Bristows there are quite a lot of background, especially chemists and engineers, but equally a few of the partners and definitely they have like law degrees or you know, it's a real mix. I just really wouldn't put it off. You know, if you didn't have a STEM background, I really wouldn't let that put you off. If you're interested in it and you're truly interested in it, just follow it. It's not going to hold you back.
I think that's probably one of the key takeaways from today, hopefully for our attendees, that that really doesn't need to be a factor for them to be kind of thinking about, as you say, if they're interested to go for it. And perhaps a question for both of you here. So Luke, we'll start with you. Do you favour the transactional aspects or the litigation aspects of the practice, or do you like them both?
Well, probably, as you can guess from the fact that I used to be an advocate before I became a solicitor, I like the litigious aspects of things. And actually, my team is not the IP team at Osborne Clarke, it's actually the IP disputes team at Osborne Clarke. So I'm afraid I'm a litigator through and through. Transactional law is not really my bag. So, but equally, it is for a lot of people much prefer it to litigation. It tends to be a more steady pace, less peaks and troughs, and more steady, not sort of average busyness. And obviously, it's slightly less contentious, albeit one or two contract lawyers I know are probably the most contentious people I know, for the record. So,
yeah. It might not be contentious in the sense that you're going to court, but against the negotiation positions, it can be quite contentious anyhow, I think is the point.
Yeah, exactly.
I'm also a litigator, so I think you can guess that I prefer litigious practice. But I oddly enough, at one point I was nearly going to become a construction lawyer. So, and then it was going to be all contracts based. You just really you can't tell until you try it, I think.
Yes.
I was just about to ask off the back of that, what made you kind of change your mind there?
In the end, I think I enjoyed the thrill of litigation a bit more than I did the kind of steadiness. I think to be a good contract lawyer, you have to be dedicated to doing similar things and getting better and better at them in a kind of incremental way over a long period of time, which is exciting in itself. But if you didn't find that exciting, then maybe litigation is a bit more exciting because things happen suddenly and you have to change, or you might be fighting the established law. So you say, well, that's what the law says, but it's wrong, which you don't get sometimes in transactional law.
Perfect. And Adrian, we spoke a little bit about this earlier in terms of when you were talking about interviewing candidates. Someone has asked, what are the characteristics or experiences that the firm looks for in future IP lawyers or trainees?
So I obviously can't talk about all the questions and what it is, because we are committed to our values. So if you interviewed at Bristows or any firm, you should look at those values and think about examples of why you fit into those values. But me personally, I look for people who I think are really interested in the areas of law which we do, which are life sciences and technology. And if they can't say why they're interested in those areas or why they want to practice in the areas, then usually that puts them on the back foot, because there are other firms where you could do similar work. So why Bristows? So really an interest, because in the end, if you spent your career here, you could spend, up to 40 years practicing this area. So you've got to enjoy it. Otherwise you'd be miserable.
That's great, thank you. I think that research is obviously key, understanding the firms you're working for as well as the practice that you're interested in. And also just to say that I think we've maybe touched on this, but that the theory is likely going to be very different to the kind of practical side of the law that you end up practicing. So I guess keep an open mind in a lot of respects as well. We've got lots of questions about AI. There's one here from Hannah about what other areas of law would you say are most closely related to IP law? Luke, perhaps one for you.
Ooh, now that is a good question. Okay. Also on the transactional side, IP is very close to just commercial law. I do spend quite a lot of time talking to my colleagues. We have an advertising team. Osborne Clarke's quite a big firm, so we've got quite a lot of specialist teams, but we talk about advertising and use of IP in terms of greenwashing issues and that sort of thing, which I find so they're quite close to me as well. And then the commercial litigators, the disputes and risks, in my practice, in my firm, it's the dispute and risk practice group. I deal a lot with the people who focus on technical commercial disputes, so like outsourcing agreements and that sort of thing, because IP issues tend to come in those disagreements, but sort of tangentially. It might just be a commercial dispute at its heart, but will have IP issues or technology related issues around it. So yeah, commercial disputes, advertising, and the commercial team, I would say.
Great, thank you. Yeah, that's very helpful. And I'm just going to stick with you for the next one. Someone else just asked, how do you approach advising global clients on the risks of IP and AI compliance in regions with differing regulatory standards, such as the EU versus the US?
Congratulations for just summarizing why lawyers have a job. In some respects, and I hesitate to put it like this, but in some respects, it's quite straightforward in that you look at where companies operate, and we do frequently give this sort of advice. So you look at where companies operate, you advise them on the position in each jurisdiction. For Osborne Clarke, that's going to be a lot of work with other Osborne Clarke firm like entities, or we're a Swiss Verein if that matters, but we have Osborne Clarke Germany, Osborne Clarke Italy. If it's a country where we don't have a presence, an office, we will go out to sort of preferred local counsel who are specialists, might be the client's preference, might be our recommendation. And we'll pull all of it together. And then we'll do the sort of important bit, which is not to hand them a Bible of this is the law in these jurisdictions, which frankly most clients think is totally useless. It's to draw it all together and go, well, these are the common threads. These are the things where if you can do it like this, you'll be fine across all these jurisdictions. This is the high watermark of all the issues. This is where the risk is, this is, and it's balancing lots of issues. So you might have a location with really strict rules, but if you breach them, it's a $10 fine. In which case it's not probably, it's less important, or it's less of a risk to the business than say looser rules. But if you cross them, you'll find 10% of your global turnover. So it's pulling all of that together and then talking the client through it and being willing to kind of help them understand it. Hopefully that answers the question. But if not, we'll get another one.
I think so. Yeah. No, I think it does, absolutely. And someone's just touching on the work-life balance aspect as well. Somebody has asked, can you manage your time in the way that both of you were able to do as someone who isn't perhaps an associate director of counsel? Adrian, I don't know if you want to answer that one.
Yeah, so it depends on the firm again. So I don't want to, it's hard to answer broadly. But at Bristows, yes, there's obviously more formal arrangements. So some people have different working times, and that is you have to do a formal HR request. But there's generally, for all associates as well, there is just an expectation that they will get their work done. and how they do that, as long as you're in the core hours, is up to you. So there's definitely people who don't like getting up early and get in at 10 and maybe work till 7. There's people who like getting up early, get in early, and then have a really long lunch, then might go home and go to the gym or go for a bike ride and then work in the evening. But those are flexible arrangements. So the same as mine. I don't have anything formal. If I have to be in the office, I will be in the office. It means I can't say, for instance, guarantee that I'm going to leave at 5 or 5:30 for childcare arrangements. I can't do that because I might not be at short notice, but it does mean that normally there's a lot of flexibility in moving things around. It's a bit different when you're a trainee, but as soon as you become qualified and you can, you don't need that direct in-person supervision, then Bristows is generally quite flexible and understanding. But other firms might be less so, or they might be more flexible in the evenings. You just don't know. I can't speak for them.
And Luke, I don't know if you want to add anything to that, or if you feel Adrian's covered that.
We're very flexible. I think there's a bit of a changing mindset over the last few years, certainly since the pandemic, but generally speaking over the last 10 years about these sorts of things. I'm quite a flexible person, so and it's really important to me that, like, the associates who might be working for me don't feel like they need to not do what I do. I sort of actively encourage them to have a flexible life too, because I think it's really important, and we can, frankly, we're all grown-ups. And Osborne Clarke's very supportive of that sort of side of things. Everyone's got different reasons for needing to be able to work flexibly to a degree, and they're all important. So we accommodate it as much as we can. As Adrian noted, we are professionals. So sometimes something comes up last minute and it's an issue, but equally, last night at 8 o'clock, there was an emergency. A client needed a call. A colleague took it for me because she knew my wife was out and I was putting my kids to bed. So, so family does come first, equally sometimes, and you can be reasonably certain with your time. It's just being flexible. If you're flexible, then the firm will be flexible, has always been my experience.
I think we should say, though, Luke, that it's not just families.
Oh yeah, sure, absolutely. That's why I said whatever your reason for, they're all.
I think we both have families, and that's why we require flexibility. But other people just do it for interests or other reasons, or it's not. We don't want to give the impression that you're only flexible if you have a family. That's definitely not what we want.
Yeah, and I think you've both mentioned kind of looking into the firms that people are interested in. I think there's obviously lots of law fairs coming up for those of you that are here attending today. So just make sure that you speak to people if this is something that's important to you. Ask those questions. Have a look to see who's attending the law fairs near you. Make sure you kind of prep some questions ready to ask. And if that is work-life balance is one of those that's important, then absolutely. I'm just conscious of the time. Apologies to attendees. We didn't get through every single question today, but I think we did pretty well. I would like to close with just some advice. So, Luke, I think this one was for you. So if you'd like to share one piece of advice for someone considering a career in IP.
Sure. So I think you should remember, so when you come to an interview, whether it's at Bristows, Osborne Clarke, or wherever, you have been invited to that interview because we think you are capable of doing the job. So what we want from you at that point is to know who you are, why you want to work for us in particular, why you want to do the area you want to do. So you need to show us that you're curious, that you're interested in talking around subjects, and that you can think slightly laterally. And a good example is, if I ask you, compare these two, I don't know, bath products and give me your view as to whether it's naughty that these people are selling this generic bath product versus this other one. A good answer is, here are all the reasons why it looks the same and why that's bad. A great answer to that is, well, that's all great, but at the end of the day, we don't want to peeve off whoever it is. If it's like a Boots product versus a branded product, you're probably selling through Boots, right? So you don't want to upset Boots, right? So it's thinking about commercial awareness, think round the problem. You know, we're not asking you questions because we think you can't answer it. We're asking you questions to see how you think. And just remember that, I think, in the interview.
That's lovely. Thank you so, so much. I'm just going to hand back to my colleague Dimitar, I believe, who is going to close up for today. But yeah, just thank you both, Adrian and Luke, for being here, and the attendees. Thanks, Dimitar.
Thank you, Liv. Some really good questions from our attendees and great insights and examples from both Luke and Adrian. I especially appreciate the Pokemon example when we actually talk more about it, about the Nintendo Pokemon lawsuit in today's commercial news roundup. So make sure to check out lawcareers.net's news page if you're interested. I'm just going to run a quick final poll to see what everyone has gotten out of the session. So that should be coming up on your screen now. Okay, give it a few more seconds. Okay. Just going to share the results. It seems a majority of you have said that you know what a work of a solicitor in this area involves, which is great, as this is the point of the masterclass. And many of you have also learned about how to break into the practice area and know the key issues facing the practice area right now. Thank you for that. It's great to see what you've taken out from the session. Before you go, just another reminder to attendees that we will be sending out a link containing the recorded session. So please keep an eye out for that. A survey will also be popping up once this masterclass finishes. So please do fill that in to let us know how you've enjoyed today and what other topics you would like us to cover in the future. Remember to also check out all our upcoming masterclasses on the events page on lawcareers.net. And thank you very much once again to Adrian and Luke and to everyone attending today. And we look forward to seeing you again in the future. Thank you.